rejects embattled CJN Walter Onnoghen's bid to overturn the ex parte order that suspended him in the first place. And then we have heard that the NJC has given 7 days to Onnoghen and Justice Tanko Mohammed to respond to petitions against them. What about the lawyers' boycott? We hear they're quite divided on that matter. Some did go to court, some didn't. And then we're going to focus on the new CJN, or rather would I say, the acting CJN, Justice Tanko Mohammed. Who is he? Is he really unqualified? Is his action really as unethical as people say? Or is he really just a victim of bad press? You're watching me, Lord, right here on Roots TV Nigeria. My name is Gloria Ojemode, and a lot of things to talk about right now. The developments have been so many in this case. When we started this show, to be very honest with you, we didn't see it culminating to this point, and from the information we have, this could continue till even after the elections. Right now, I have two distinguished guests in the studio to discuss these new developments with me. I'm bringing back Atsukwo Mendi Achibong. He's a doctor of law, and let's not forget, he's a presidential candidate for the Nigeria for Democracy. It's good to have you back on the show.
Thank you so very much, Gloria. I'm glad to be here.
All right, and we have Aliyu Abdullahi. Aliyu Abdullahi is a legal practitioner with an interesting view on what is going on so far with the case of the acting CJN and the embattled CJN. Welcome to the show.
Thank you for having me, Gloria.
All right, let's start with the most recent development. 24 hours ago, we heard that the appeal court has rejected Justice Walter Onnoghen's bid to overturn the ex parte order by the CCT to suspend him. Now, some people would have asked, why did he even make that appeal in the first place? Was it cosmetic? Was it just, you know, to stall what's about to happen? Some people are even asking, why is he still fighting this? Shouldn't he just wait until this NJC has done its part before, you know, moving forward? Why is he still at this point? I'll start with you, Mr. Achibong.
Look, let me put it this way. When there is an appealable order, what we're hearing in this instance of the ex parte order by the Court of Conduct Tribunal, you have the right, regardless of who you are, to take the order on appeal if it is not favorable to you. And that's exactly what Chief Justice of Nigeria Onnoghen did. Now, it's not exactly clear if it was the appeal that was dismissed at the Court of Appeals, the Abuja Court of Appeals, or if it was a prior motion that he filed.
Yes, because we know he filed a prior motion. So that's a bit dicey right now. We're trying to figure out what was it that was stayed. The word that we have been getting stayed. I mean, you are the lawyers here, and I'm just the journalist, and I'm trying to understand some of these words. It was stayed. So we are still trying to get the clarification on which particular motion that was stayed. But it is generally believed because he went to court to challenge this ex parte order by the CCT, and some have said backdated, which led to him being suspended in the first place.
Well, when you look at what came down from the Court of Appeals, it said that the motion to stay the proceedings at the Court of Conduct Tribunal has been dismissed. It's because it's now a moot issue that the Court of Conduct Tribunal has adjourned indefinitely, per se. So there is nothing for the Court of Appeals to stay.
I see.
And that might be the reason that they dismiss his motion to stay.
But shouldn't he have known this was going to happen? That's why I asked the question. Did he just do it for cosmetic sake? Did he just do it so it is penned down that he actually did appeal? Because you would have thought, because I don't know, a lot of people didn't expect anything different to happen with the Court of Appeal, his Court of Appeal, would I say, appeal, if I should use that word again. I mean, nobody expected much, so why did he still do that?
Let me put it this way. The motion was not an appeal in and of itself.
Okay.
The motion, if it's to stay, that was dismissed, was something that was probably filed before the ex parte order. Now, the appeal is a different case. He has taken an appeal to the Court of Appeals to overturn the ex parte order from the Court of Conduct Tribunal. I don't believe that has been ruled on yet.
I see.
It's a motion that was to ask the Court of Conduct Tribunal to stay proceedings.
I want to get your
I think my friend here is not totally correct on this issue, because already the Court of Appeal, if he was talking about the earlier motion to order the stay of proceedings at the CCT with regards to Justice Onnoghen, actually that motion was granted by the Court of Appeal earlier. It was one of the things that a lot of people were actually complaining and arguing about, that there are subsisting orders, you know, one from Court of Appeal, another one from another Federal High Court, another one from National Industrial Court. So the Court of Appeal has already granted the motion of stay of proceedings at the CCT with regards to the, so I don't think the Court of Appeal will contradict itself again on the same motion. No one has brought another motion with regards to that. The only motion or the only issue for determination at the Court of Appeal was the issue of challenging the order from the CCT that was thrown out now by the Court of Appeal. I agree with him on one hand that until, as lawyers, until we study the grounds upon which the Court of Appeal threw out this appeal, we cannot really comment much on it. Actually,
I'm glad you answered that, because I was about to ask you, what was he challenging? The legality, the jurisdiction? What exactly was he challenging? So
exactly. On the basis, the grounds that the court that actually gave, because it's a judgment in itself. You know, dismissing a case, dismissing an appeal is a judgment in itself. So they have to give reasons for that.
This order has been contentious, because there are been some people who said, first of all, it was backdated, it really wasn't something that came up at the time. Some people have challenged its legality. I mean, even the president's constitutional right to even use it, the CCT's, you know, authority to even give that order. And a lot of people have challenged so many aspects of that ex parte order. So I guess maybe that's why he went to court to appeal that. I don't know, but like I asked earlier, did he really think he was going to make a difference, or did he just do that because?
Here is the thing. We don't really know what was dismissed. So we'll wait.
Yeah.
I may be correct, he might be correct. But let's wait and see exactly in detail the reasoning behind the dismissal by the Court of Appeals, and then we will know exactly what was dismissed. In getting to your question regarding whether it was really a cosmetic activity or not, I think, as I said, he has the right to appeal an ex parte order for the same reasons that you have mentioned. Some have stated that that ex parte order came after the court adjourned.
Yes.
Some have stated that the ex parte order didn't have the name of a moving attorney or barrister lawyer on it, which it should. Some have stated that the issue of jurisdiction was not exactly determined, which is what the Court of Conduct Tribunal should have determined before issuing an order.
Exactly. So these are all the things that came up based on that. Still on this, let's go to the NJC. Finally, the NJC sits. Now, here are a few things that I've had issues with. You know, all of this while people have continued to say that due process wasn't followed, because of course the NJC has the ability to discipline its own members and itself, of course, which Onnoghen, though a chair, is still a member and is still subject to the NJC. Only for us to find out that Onnoghen himself postponed indefinitely the sitting of the NJC, which would have deliberated on his matter. So I have asked this question over and over again. Did he somehow try to truncate due process? I'm just asking a very simple question, because we know that he postponed indefinitely this NJC sitting just the day, that's on the 15th of January. So could he have done something wrong? Could that also have been attributed to him as trying to usurp his authority? I want that question to both of you.
Yeah, here is the thing.
Please, Ali, I want you to start on this one.
All right. Well, you see, the greatest principle of law in fair hearing, you know, in natural justice is audi alteram patent. It's an Latin maxim.
English, please.
Yeah. It means simply you cannot be a judge in your own case. No one should be able to sit and judge his own case. So the NJC, the CJN is the chairman of the NJC. He's the head of the judiciary. And yes, like you rightly mentioned, he actually postponed the meeting indefinitely. I had some of the members had earlier arrived Abuja for the meeting, but then they actually got to read the text message that it was suspended. Now, besides this issue of NJC, because NJC will have definitely, this issue will have come before the NJC, they will have discussed it and taken a position. Yeah. Perhaps we wouldn't be where we are. We will not be discussing whether the CCT has to really intervene or the president has to resort to accepting an order from CCT and then the issue of the legality of the order and so on. Maybe if the NJC had met and taken a position, maybe we wouldn't be here discussing all this. Now, besides the postponement of the NJC, you have to look at how things have come together. You know, a pattern. There is a pattern that the CJN was, that has established that the CJN was not willing to submit himself to the, to submit himself, exactly, to the judicial process in defense of the charges of those allegations against him.
Why do you say that? Is it just because
no, that's where I'm going.
This, or because he refused to appear in court, appear before the CCT?
Good question, Gloria. That's why I say you have to link it to find a pattern. One, exactly that what you mentioned, the lack of appearance before the CCT, the many court orders coming in trying to muzzle a recognized, constitutionally recognized exclusive court to deal with breaches of that nature of code of conduct. The CCT is the only court, as was actually enunciated by many rulings, especially that of the embattled CJN himself. So now when these court orders came, some from Federal High Court, another one from Court of Appeal, another one from even industrial court that deals with labor matters, has nothing to do whatsoever in regards to breach of code of conduct, still gave an order for this court to stay, not to actually try the CJN. Now, what does it have in common? If you are an ordinary public servant officer, will you have had all these courts to give you these orders to do that? So you see, it has to come with your blessing.
Makes a lot of sense. Before you go ahead to talk, Mendy, I am very aware that you have a lot of things to say, but I want to ask this question to both of you before you even respond. You said, a lot of people have said, the presidency has said, the normal thing is, why not step aside and let the law take its course? And I ask this question, why didn't Bukola Saraki, why wasn't he asked to step aside when his case before the CCT came up? Now, even
some people asked.
Hold on, even the chair of the CCT, Danladi Umar, right, who is chairing this, was charged by the EFCC for taking 10 million naira bribe by a litigant. He is sitting, chairing this case. He has not been asked to leave the chair as the CCT chair. So why is there the need to ask?
Yeah, I'll tell you why after he made
Onnoghen to step aside when his case is being tried. Why isn't he being treated like everybody else who, like they say, you are innocent until proven guilty? I want to understand that. Mendy, you have something to say before I come back to you.
Yes.
Well, here is the thing. When you look at the chronological sequence of events, you're going to see that there's been a lot of shenanigans. And
both sides. All right.
Okay. I can't go to the Court of Appeal and get an order because the Court of Appeal is the second instance of a hearing. It's not an originating court.
I see.
Okay. And that issue, I believe, will also be addressed, hopefully, by the National Judicial Council.
Is that why they also served the petition to the head of the CCT? Because I know the NJC, there is a petition against Danladi Umar on that by the NJC. Do you think that is related?
A separate individual or organization filed a petition against the chairman of the Code of Conduct Tribunal, but he misfiled it before the National Judicial Council. So the National Judicial Council referred that petition to the
Federal Judicial Service Commission.
Yeah. Which is where it should go. That's who has jurisdiction in this matter. when you talk about the activities of the Chief Justice of Nigeria, the Honorable Justice Onnoghen, making himself unavailable to appear before the Court of Conduct Tribunal, of course there is the challenge of service of process.
We got that part. His personal assistant was served at first. But I remember when we went back to court, that was on the 22nd, yes? When we went back to the CCT, the first question, I was in that court when the Dalari Umar asked, why is he not here? And it was established that he was served in person the next day. In fact, on the 14th of January. Okay. That was after the CCT sitting that first day. Well, so he didn't show again. And of course, Olani Beku, who is his lawyer, said it is still a case, there's still a case of jurisdiction here. That's why he hasn't shown.
And here is the thing. In different instances where there is a challenge to jurisdiction, and also there is an order from another court that might be a court of higher authority.
Like the Court of Appeal here.
Someone can take refuge in either of those two things and refuse to appear. It's at the discretion of the judge.
Ali, you seem to so reject this. Although there are two questions. Yes, do you want to respond to him or the question I asked? Why are you asking?
The two of them actually, because they are interrelated. Okay, it happens. So
go ahead.
Yeah. You see, let me tell you something, Gloria, and it's so
it's like the
platform of to say this.
Okay, great.
There are some lawyers who are so good in taking advantage of technicalities to cause delay, you know, in proceedings. This is why in Nigeria it's so difficult to actually prosecute people, especially corruption cases. It takes 12 years actually to convict the last two high-profile cases we saw in Nigeria, the former two governors, you know, of Jos and Plateau and Taraba. And this is why, because of lawyers. We are the ones, most of the times, that are at fault. With due respect to some of my senior learned colleagues, they take pride in that experience of using technicalities. Preliminary objections of jurisdiction and cause of action and things like that, we call it PO for short, are what lawyers will use to make sure they continue to take the case till they go up to the Supreme Court, come back, take another preliminary objection on another thing. The CCT has been adjudged. There is a Supreme Court case, and a very recent one for the matter, in Saraki versus the Federal Republic of Nigeria, where the Supreme Court established, held that the CCT is an exclusive court empowered by the Constitution to hear the matters of breaches of code of conduct. So they have jurisdiction.
They have the jurisdiction.
The lawyers know. The CJN that his lawyers acted on his behalf to challenge the jurisdiction of the CCT was the very person that passed the judgment affirming the jurisdiction of the CCT in the Saraki's case. Now this is the person whose legal defense team is questioning the jurisdiction of the CCT. Now, you ask me again, why people didn't call, why there was no so-called on that on Saraki and Aladi Umar and things. And I will tell you this, although there was on all these two people, yes, they were not as, the call was not as heavy, as raw as this one, and this is the reason. Because the Chief Justice of Nigeria is a position, is somebody that should be unblemished, untainted, should be beyond reproach. He must be somebody that is squeaky clean. Lord Denning Emmer, a British jurist, you know, said a judge must be above board in all matters that concerns matters of integrity.
Any speck of doubt, step aside.
Exactly. So what I'm saying is the position, because he's the head of judiciary, is so enormous that we cannot actually keep quiet.
There is any speck of doubt, step aside. What do you say? I mean, you have practiced law in the United States, so correlate this for us. Let's not just be like we are in one isolated environment called Nigeria. In the United States, is this also applicable? If there is any speck of doubt, does the CJN have to step aside?
All you have to do is take a look at the process of affirmation for the last Justice of the Supreme Court of the United States and see how contentious it was. There were allegations of rape.
Yes, of course. Yes,
right?
Yeah, that's true. That's true. That's quite true.
Here is the challenge to this instance here. Then people will bring up some little bitty issue or detail about an individual, and he will be forced to step aside, and a judicial branch will be thrown into turmoil. Let me take a step back here, and we really look at the jurisdiction issue that was challenged. There were issues of the petition being handed over or given to
his personal assistant.
No, the petitioner.
That is service.
Hold on. The petition itself, if he had the chance to respond to that petition before it was referred to the Code of Conduct Tribunal. Remember, this was an abbreviated time frame. They served the Code of Conduct Bureau, and immediately it was referred to the Code of Conduct Tribunal. The issue of jurisdiction was not, this is not the appropriate court. The issue of jurisdiction was, this court does not have the power at this time because because the Code of Conduct Bureau has not received an answer, and even if it has received an answer, that answer ends the case right there because the Chief Justice of Nigeria said, "Yep, you got me."
All right, do me a favor. Do me a favor. To the ordinary Nigerian who's watching us, go through the step again. So the Code of Conduct Bureau
is supposed to
receive a petition from who?
It's irrelevant who
let's say the executive. Let's say
not from anyone. From anyone.
Blew the whistle.
Okay.
Yes.
And they're supposed to send that petition
to
the Chief Justice of Nigeria.
Okay.
Giving him an opportunity to respond. Right?
Now,
not necessarily. There is a Court of Appeal that says actually the Section 3, that they are relying on, that is not a good law.
They have to give him an opportunity to respond. Now, here is the thing.
It doesn't matter even if he didn't respond.
One of the things that happens with the response is if a person says, "Yes, you got me. I made a mistake here. This was an error. Okay, I lied here. Whatever I did."
That is all and good and fine, but it's not. I assure you, it's not. There is a Court of Appeal decision.
Under Section 3 of the Code of Conduct Act is a defense in and of itself. Because if the person says, "You got me, I'm going to make the corrections," the policy behind the Code of Conduct Act is to encourage civil servants to actually put out their asset declaration forms, okay? Make it accurate. So this person says, "You got me. I'm going to make the
all he needed to do was to declare his assets at the time, and it's A-okay. So you're trying to say, in this situation that a lot of hula baloo, if I should use the word, was made over something that could have been settled with, "I'm sorry, let me get this done."
He already said, "Listen, I made a mistake here. There is an error here."
They say it's a criminal case, and you've gone
here, look at the law. You have to go back to the law. The law says if a person admits, in this instance, under Section 3, in this instance, then the Code of Conduct Bureau will not refer the case to the Code of Conduct Tribunal. So what were they referring? There is no dispute here. You only go to the Code of Conduct. So he already accepted. So why were we?
You see, let me take it from here. I think my learned friend has actually gotten it wrong, and this is why. The essence of the Code of Conduct Bureau, the filling of the form, is not, like he said, to help public servants to, what did he say? Sorry, I forgot. He said to fill the form or something. No, really no. A big no. The essence is to actually fight corruption fundamentally.
Number one.
That is it, to fight corruption, to make them more transparent and accountable. And this is why, before you commence an office, your assets are to be known, and your income in the next 4 years is already known. So by the time you are leaving an office, your wealth, your assets will be valued, will be known, whether you have illegally enriched yourself or what you have acquired after this term of office is commensurate with your earnings while you are in the service. That is the aim of this. It's just not to fill the form or to make this civil servant to comply. No, it's to actually fundamentally fight corruption. Now, let me tell you, the section that a lot of analysts and commentators were relying on, that if the CJN has admitted that he was in breach,
Yes,
it's a mistake or forgetting, or that there was no need to have taken it. Yeah, there was there was such a provision. But there was also a court of appeal that negated this particular provision as a bad law, meaning that where a case was taken before the CCT as a breach and as a criminal case, that Section 3 ceased to come into operation. As long as it's taken before the CCT has jurisdiction to hear it. That's the issue. If they didn't do good and fine, but once they take it to court, Section 3 is not operable.
Just one question before we go to the break.
Yes.
Why now? Why is it just now that it was discovered that embattled CJN Onnoghen had not declared his assets? Why now?
Is there a better time to fight crime?
No. Why? The reason I'm asking that is because there have been speculations that all of this is leading to the elections.
Yeah.
Why now?
But I answer you, is there a better time to fight crime in our laws in this country? Can we not fight crime any number of days, any day, any time?
Saying it's not a crime. Now,
no, it is crime. Actually, it's no, it's a crime.
Before we go on that break, let me at least respond
very quickly, like in 30 seconds. I need to get that.
He asked, is there a better time? I think what I would simply say is that there is no better time to fight crime, but the method with which you fight the corruption in the country might be inappropriate as it is instance.
Alright, you're still watching me, Lord, right here on Roots TV. Feisty conversation. There's still more to talk about. The lawyers, a boycott, and then we get to know acting CJN Tanko Muhammad. Now, I've asked the question, is he really as unqualified as people say? Because some people tag him as a Sharia lawyer, a Sharia justice, a person from the Sharia law. That is what he is. And then some people have said, did the fact that he has accepted to be the acting CJN, did he break any ethical laws? And then, I'm really asking, I mean, a lot of people are asking, could this man be a victim of bad press? All of this we'll be finding out right after this break. Stay with us.